Good morning, and welcome to the reboot of the 32nd Annual Employment Law Review and Update. My name is Kelly Trudell, and I'm the Director of Business Development at Sheehan Finney. While we certainly wish we were all at the Castleton today, we're very pleased with the strong response to the virtual program. Please note that part 2 of this reboot program will take place on November 19th. Please visit our website to register for this and several other webinars planned. A few housekeeping items before we begin. This program is being recorded. We will post the audio and slides later today on our website as well as LinkedIn. Information on HRCI credits is also included on the final slide. We encourage you to ask questions. Please use the Q&A tab at the bottom of your screen. The speakers will address all questions at the end of the presentation. We will do our best to address as many questions as possible. The program today will be led by attorneys Jim Reedy, Mark Ventola, and Karen Whitley. Jim is co-chair of the employment group. He practices in the areas of management side labor and employment law with an emphasis on assisting laborers in effectively avoiding or defending against employment disputes. Mark Ventola is also the co-chair of the employment group. He is a regular speaker on employment topics and serves as outside general counsel to a number of privately owned and family businesses in a variety of industries. Lastly, Karen is a shareholder in the employment and litigation groups. She focuses her practice on management side employment litigation and counseling, including discrimination, wage and hour, and restrictive covenant proceedings. Thank you for sharing your morning with us. Now, please, Jim will take over from here. Thank you.
Thank you, Kelly. Good morning, everyone. Hope everyone's doing well on this rainy Thursday. It's not May. We're not in person like we typically are for our labor and employment seminar, our annual event. But we're, like anything else in this era of COVID, we're making do, right? So we just thought it was important to get back in touch with you folks. I mean, our firm started a COVID task force in March, and Mark was a part of that. And we tried to do, and we continue to do, regular updates through LaborNet, through our mailing list, to contact with our clients and other contacts, because this is an ever-evolving area of the law responding to the pandemic. But we thought a webinar like this, a reboot of some of the topics that we're going to talk about in May, but others that have come up since then and been refined since then, was a good idea. So we're thrilled to talk with you today, and the group that will talk with you on the 19th, Liz Bailey, Brian Bouchard, and Megan Carrier. But let's get started with where we are today. And we love the concept here, which is clarity in a COVID-changed workplace. And that's sort of where we are and where you are. Who would have thought at the beginning of 2020, when things were just so rosy, the economy was buzzing along, unemployment was low, things were looking up, and then we get the hit with the COVID. It's similar to what someone described recently as 2020 is going across the street, looking both ways, and as you step out, you're hit by a plane. You know, it's just, holy cow, who would have guessed? But HR has had to step into the breach. You've had this situation where you have to, on the one hand, understand what COVID means, the public health crisis, and then dealing with emergency orders from the governor's office, whatever governor we're talking about, because you folks have operations in more than one state, and then the stay-at-home orders. And what did that mean for your workplace? And did that mean a shutdown with furloughs and layoffs, or did that mean scrambling to find laptops for people to go remote? And then dealing with the FFCRA, first of all, understanding it. Secondly, explaining it to the C-suite, and then to your employees. And then developing policies. And then from there, understanding the CARES Act and the PPP program, getting employees back to work if at all possible. And, you know, all the while trying to operate your business safely. What that means, however, and that's the purpose of my operating your workplace in a safe fashion. And just trying to advance my screen here. Just having a little technical difficulty here as far as advancing the screen. So just bear with me for 1 second. But as we do, we all thought that by midsummer we would be back to the new normal and what that meant. I mean, starting in June, July, employers were starting to get their employees back to work, whether it was returning from furlough, hopefully returning from layoff, or just transitioning from remote back to the workplace, or getting used to having employees work largely remotely. We thought it would all be over by summer. And now here we are in late October, and it continues. And now we're looking at the potential for a second wave. And with that, employers still looking at, how do I get people to return safely, that they're comfortable, that we're comfortable, that we don't have an issue. I'm right now dealing with, and others in our group are dealing with, DOL OSHA audits, dealing with CDC guidelines and New Hampshire guidelines as far as return to work. We're coming up upon the holiday season, and the holiday season, of course, is looking at whether or not employees are allowed to travel. And if they travel, do they have to quarantine afterwards, and so on. So all of this goes to a safe return to the workplace. And for those who remember the movie, The Marathon Man, by the way, that is not my picture, but the question is it safe? And in addition to that, yes, the healthcare crisis that came with the devastation of the virus, it truly has turned the workplace upside down. And these are the things that we just talked about: the stay-at-home orders, the closure for non-essential businesses, and so on. And the reason why we mention that, while that now seems like ancient history because that was back in March, April, and May, we may be back to that again for those states that do rollback, going back to non-essential businesses, potential shutdowns, and so on. Monitoring remote work is something that's going to come up more and more as employees stay remote. A recent study came out and said that 25% of employers are going to just simply keep people remote indefinitely, remote workers, because it seems to have worked out. And it's also space planning and so on. So Mark's going to talk about the wage and hour issues that are unique to remote work. Of course, there are other issues that come up, and we've talked about this before in other programs, like discrimination and misconduct issues, workers' comp issues, and so on. Karen's going to talk about accommodation, workers' comp, and other accommodations that might relate to remote work under the ADA and state law. But of course, there are isolation issues, morale issues, and so on that have come up. And one thing that JP Harris has talked about here at the firm in a couple of webinars is data breach issues when you've got people working remotely. So we all know about the FFCRA. You could probably recite it in your sleep, and the questions are with regard to emergency sick leave and emergency family leave. Family leave, of course, if the school shuts down, physically shuts down, and getting up to 10 weeks of paid family leave. That is not the same as regular FMLA, of course, but it does run concurrently for purposes of using up the benefit. But that's only if for daycare or school shutdown. Now, that could be an issue because you've got varying issues by school districts as to whether or not the school is fully remote, a hybrid, or in person. It is not the parent's choice. If the parent says, I choose not to send my child, well, then you don't qualify for that. But that does come up as an issue more and more these days. We see it on LaborNet and so on. Emergency sick leave. That is one that's come up quite a bit because the issue of personal travel has come up. And I'll address that very quickly. And that is that, of course, that is if the employee is sick, if the employee has been exposed, doctor's orders and so on, and specifically sick with regard to COVID or exposed to someone with COVID or the like, and you know the questions. The issue there, though, is whether or not the employee, following guidelines from the state with regard to quarantine because of personal travel. Again, there are exceptions for business travel and medical travel, but for personal travel, holidays and the like, if if the person goes outside of New Hampshire, outside of New England, whether or not they are subject to the quarantine order. And what does that mean? In New Hampshire, the guidelines say that you are asked to quarantine for up to 14 days. You can't test out of it in New Hampshire. And they say, well, it's asking, and you're not directed to, and therefore is it an order? That still is not settled, except to say that in at least two audits, one is an OSHA audit and another one is a inspection by a local health department, they take the position that that is an order and you must stay home for 14 days. And then the question there would be using the FFCRA sick leave. Now that would be a benefit for the employer who's covered by the FFCRA, meaning fewer than 500 employees, and then you get the payroll tax benefit. But that's the issue that's come up. And the other issue that's come up is in certain environments, can we deny sick leave, or time off or travel rather? Just back up, can we deny someone's vacation request between now and the end of the year? Because we know that they go on vacation, they're outside of New England or exposed to someone, then they're gonna have to quarantine for an additional 14 days after that. And the answer is, you certainly can. We've been dealing with several employers that are denying and saying, but you can carry over your benefit to next year. Now that represents certain morale issues as well. But so the other issue that comes up is the tension between the Paycheck Protection Program and the CARES Act. Now, that's less of an issue right now because the CARES Act, of course, was that augmented unemployment benefit through July 31st, and it's an additional $400 on top of what the employee was already receiving. And some employees received the same or more than they would have received had they been at work. So creating an incentive not to be at work, and the Paycheck Protection Program, of course, being the incentive for the employer to take that low interest loan to have it actually forgiven if they maintain payroll and so on. That's less of an issue now, but if there's a new stimulus package, that could be back with us again. So reopening itself, of course, has had its own issues, which is closing school partially or the hybrid, like we talked about, the impact upon the emergency family leave. CDC and NH and other states screening requirements, and those remain the same. There's been some refinement, and I'll talk about that in a second. But in a PPE compliance in the workplace, that has come up in our OSHA audits that we've had so far. They follow strictly the CDC guidelines. Employee other safety concerns and the changing state guidelines, and we've seen that in several states, and quarantine issues that continue to linger. And what does it mean to quarantine and so on? We've actually had questions about employers monitoring employees' Facebook to make sure that they're actually safely quarantining and not going to play golf or otherwise, not staying home. The legal issues that come up, the FFCRA, we've been posting a lot of stuff on those benefits and compliance issues. And again, the FFCRA is around till the end of the year, December 31st. And FMLA benefits and how they run concurrently. Again, Karen's going to talk about workers' comp and ADA accommodations. Privacy concerns have come up as well with regard to the medical information you might have and how it is shared. OSHA safety concerns. OSHA's come up with some interesting guidelines in the last 6 to 9 months. And as far as the OSHA 300 report, as far as what it means to have a safe workplace, and so on. But like I said, we've actually had, and the U.S. Department of Labor has been very active, and they will continue to be for purposes of monitoring what's going on with workplaces in this COVID era. Discrimination, care for family members, it's an association issue under the ADA. That's entirely possible as well. And then, of course, PPP compliance, because there has been fraud and abuse in the PPP era. And yeah, going back to a favorite movie of mine, Jaws, we're going to need a bigger boat, perhaps staffing up in your HR department or just expanding your library for purposes of compliance issues. So how do you reopen and return some or all employees to the workplace, whether that workplace is remote or in person? I like this checklist for a safe return to the workplace, whenever that is. And I think the important thing to mention in that regard is that this may be a rolling back and a rolling forward for at least the next 6 months, perhaps even a bit longer. Not to be a bummer on a Thursday morning, but that's entirely possible. So adopting clear policies and communicating those with your employees. Here's one though, and it's going to sound silly, but daily screening of all employees. We've found, and this has come up through a couple of different sources, we've found that employers have gotten laxed now in October with regard to daily screening. Remember back in March and April and May, whether it was taking temperatures or asking the 4 essential questions under the CDC guidance, we found that some employers have really sort of slipped in that regard. If we're going back to a wave 2 or wave 3 with regard to COVID, it's important to get back to daily screening of employees, asking those questions, whether they have symptoms, what their temperature is, even though that's not determinative as much anymore, but whether they've been exposed to, whether they've traveled and so on, and adding travel to that outside of New England. And that changes, by the way, almost daily. States put on the list other states that they say you can't travel to without having to quarantine afterwards. Masks and social distancing, that's become the new norm. Single-use bathrooms and kitchens, of course, one-way corridors, conference rooms, looking at density, and limited time for interactions. CDC guidelines talked about no more than 15 minutes. Some say as little as 10 minutes for purposes of interaction with others face-to-face. And that's typically unmasked, but more and more, of course, we're seeing that masked. Limiting standing desks. Why is that? Because if you're standing in close quarters for purposes of, and you're unmasked, the possibility of transmission. So keeping people sitting and distant from others, sufficient spaces in between. Proper ventilation. That sounds odd, and you can't open windows often, especially as we get colder, but making sure your HVAC is working properly for purposes of ventilation. Getting away from shared spaces and equipment, and signage, of course, are important as we come into cold and flu season. It's sad that we have to remind people to wash their hands, but I think it's a good idea. No shared food or beverages. I heard a case yesterday where a 20-something employee shared a drink with someone in the workplace. Here, try a sip of this. And oh yeah, the employees both got sick. So, I mean, that's kind of silly. I mean, all of our mothers would just be amazed that we were still doing that as adults. Still, most employers have cut back on non-essential travel, and I think that will be the way for the time being. Essential travel is still permitted. What your quarantine expectations are, I think clearly communicating that to employees. Reporting outbreaks should not only be the employees, but to the extent that they've been exposed to someone else outside the workplace, and of course, supervisors following up and monitoring what's going on. And reporting noncompliance. Sadly, that has to be a reality where coworkers are saying, you know, so-and-so hasn't been wearing her mask, or I want to tell you that I know that so-and-so's family member has COVID and yet he's here in the workplace. Or so-and-so has been coughing and sneezing and I don't think it's allergies and I don't think it's a cold and I'm concerned. So HR having to follow up on that as well. And of course, the consequences for noncompliance. So you're encouraging people, if you see something, say something, but then you have to then follow up if there is noncompliance with your policies. And again, that you've clearly communicated with employees. Yes, forget about handshakes and hugs. I think those are gone for the foreseeable future. We're coming up on the holidays, so what about holiday parties? And I think that's right, maybe next year. You saw the new guidance that came up from California with regard to Thanksgiving gatherings, and they seem kind of ridiculous, but I think that could be the new norm. An uptake in sick leave. Update comes from the New Hampshire task force, but it's true in a lot of other states too, which is basically you may want to look at your sick leave policy and make it a bit more flexible. Again, keeping people that are sick or exposed out of the workplace for the time being, and perhaps allowing carrying over until next year. Does that mean paid leave? Well, if you've got FFCRA, use that first and then paid leave afterwards, but maybe being a little bit flexible in allowing employees up to a certain point borrowing their time. Regular deep cleaning, of course, is the new normal. Contact tracing is important for purposes of if you're allowing people into the workplace and for purposes of notification, because the Department of Public Health will be asking those questions, and a procedure for how do you deal with a suspected or confirmed exposure. Minimize contact. Of course, you're going to be not in person as much as possible. Be flexible with remote work policy. We talk a lot about that. What does that mean? Karen's going to talk a bit more about that, but we have done programs on remote work and managing remote employees, staggering work shifts, partial times in the office, and of course, being mindful of the challenges that parents have with school-age children and children in daycare. Big issues that come up as far as just being flexible, and it's going to be monitoring that remote work. Karen's going to talk about ADA accommodations. They're on a case-by-case basis like any other accommodation. Monitor workplace illnesses and maintain those confidential medical records. And then, if at all possible, shut off cable news and focus on truly the guidance from the CDC and your applicable state guidelines. So what happens if there's a case? Of course, candor by the employees is encouraged. I'm not feeling well, I've been exposed to, so you can act appropriately. Training your supervisors to monitor, notification of employees and public health officials as needed in your emergency communication plan, and beyond deep cleaning, plans for shift supervision and changes and facility shutdown. And if you're union, point of contact with the union. If you don't have a union, directly with the employees about what this is going to mean for shifts and the like. Authorization to deal with the employee's healthcare provider if necessary. Plan for access by public health officials. We've had that come up in a few instances where they come into the facility and look around. You have to have a plan for that. Training supervisors on what to say and what not to say, which of course is important for in all areas of employment. And then that plan for return to work individually and corporately larger. Document all actions taken because that could be judged later. Business travel. It is allowed, but it should be essential business travel. We talked about personal travel, which is the guidance says limited as much as possible. And employee fear. We've had a lot of that in the last 6 months where I don't feel comfortable returning to work. I don't feel comfortable because of, and addressing that, whether it's rational or not. That is the job of HR as well. The duration of accommodations are on an as-needed basis and per employee. Again, Karen's going to talk about that. And the duration of remote work likely will be the same for purposes of on an individual basis and what the company's needs are as well, the employer's needs are. And what happens when FFCRA is exhausted? Well, that typically would be PTO, and then for those employers that are covered by FFCRA. And then when it's exhausted, PTO is exhausted, it could be unpaid leave as an accommodation. So what happens if the employer refuses to return to work? Well, you talk to the employee, avoid the blanket rules and understand, it could be that interactive process. Why is it you don't want to come back to work? And does your medical provider say so? And if so, what's the documentation? And then let's talk about that. And avoid that knee-jerk reaction, which is, listen, you're back to work or you're fired. Now, that may be what happens, but it's entirely possible that it's a misunderstanding, or perhaps with some communication, the employee is able to return to work either in the office, full-time, part-time, or fully remote. Is return to work and absolutely necessary? Not in this era, as long as they're working somewhere. But Woody Allen's point, a quote of 80% of life is just showing up. It all depends, but you could be showing up, but remotely. So the keys to a successful return to work focus on first establishing, maintaining a truly safe workplace, listening and responding to employees' requests and concerns. Daily screening is essential, and getting back to that, regular monitoring. In addition to that, preparing for the worst case scenario, having that emergency plan in place, hope for the best, and when in doubt, yes, for purposes of legal compliance, call your lawyer. I hope that's been helpful, and I'll be here for questions at the end. We'll be looking at that. Please do put your questions in the Q&A section. Lots more coming along for sure. But in the meantime, I'd like to turn it over to Mark, talking about unique wage and hour issues for remote workers. Thank you.
Good morning, everyone, and thanks, Jim. As most of you know, when we do these programs live, I typically take the part that deals with wage and hour issues, and this year is going to be no exception. I want to spend a few minutes giving you an update about some of the things that have happened recently, just in general terms from a wage and hour perspective, but also talking about some of the things that we as a group have seen that are unique wage and hour issues that come up and have come up during the COVID crisis. So if we can flip to the next slide. Obviously, remote work and work from home has become the norm these days. And that presents for most of us a number of challenges, most employers a number of challenges that are new to them. But it also presents challenges that we as employment lawyers and those of us who focus on wage and hour concerns and wage and hour litigation have been seeing for a number of years. Remote work, as I'm sure most of you who are now needing to manage it, and especially to manage employees who typically work on a non-exempt basis, that is an hourly rate basis. They are paid for their work by the hour. Remote work presents real challenges and real compliance risks for any employer that is trying to manage a now larger remote workforce that is made up of at least some non-exempt hourly paid employees. And the reason for that, the base reason to that, goes back to what the Fair Labor Standards Act and state wage and hour laws say about an employer's obligation to pay employees who work on an hourly basis. And the law says that an employer has that obligation. An employer must pay an employee for all time that the employer suffers or permits the employee to work. Suffers or permits. Rather unique language, but it is the guidepost. And so employers need to be extra vigilant now and to train their managers to look for the kinds of things that might present a risk of wage and hour litigation. Now, in years past, we have seen this. Pre-COVID, we've seen this, where cases, often class action cases, are brought by groups of employees who are saying, I've done lots of off-the-clock work, or my manager has told me the company does not allow overtime, and yet the manager knows I'm working overtime, but doesn't allow me to put that time in and be compensated for it. That's a real problem. It's always been a problem, and it's very difficult to defend those kind of cases. But the Department of Labor just in August came out with a field assistance bulletin that talks to that very issue, and it talks to what managers should be doing and what employers should be doing. Employers are in these circumstances where you have employees who are working off the clock and then later seek to be compensated for it. The Department of Labor is now saying through this field assistance bulletin that that obligation would only exist if the employer has some type of constructive knowledge that the work is going on. Constructive knowledge, meaning the employer should know. So what you really need to do here is to train your managers to do and to look for a couple of things. One is look for those late night emails or weekend emails from hourly employees who should not be working at those times. That's a key. That's something that an attorney suing a company for a wage and hour violation would point to and say, the manager should have known. The manager should have had constructive knowledge. So train your managers to look for those things. Train your managers not to be sending hourly employees emails asking for them to do work during off work hours. Wait until it is the standard work hours that the hourly employees are required to work. Also, you should have, and I think most employers now do, have a good system for recording time worked that includes the ability to clock in and clock out for breaks, right? And I think most payroll services provide these I know most payroll services provide these kind of systems, and it's very easy to get them, to put them in place, and to keep them in place so that your risk of having some kind of a compliance issue, be it an audit from the Department of Labor or the state equivalent, or worse yet, litigation from employees. All right, so next slide, please. The next thing I wanted to talk about is PTO considerations. We have now been getting plenty of questions about PTO time, and this was frankly expected. The questions are coming often from smaller employers that have been even shut down completely during COVID and are now back to work. The employers are saying, well, we're finally back to work. We're finally getting back up full time on a normal basis. But in order to remain financially solvent, to remain financially viable here and to continue as a business, we need our relatively small workforce to be here and to be working for the rest of the year. So can we change PTO accruals? Can we prevent employees from taking PTO time? Can we stop further accruals? Those are the kind of questions we're getting quite a bit. I would say to you a couple of things on this, to all of you, and I know from looking at the attendance, which is very large, we've got folks from a number of different states on here. I would say first, in thinking about those kinds of issues, you need to look at the law of the state in which the employee sits. The laws of states are different on these points. There are some general things that I'll talk about, but every state law is a bit different. Second, you need to look at your own individual policy and see what it says about PTO accruals, about carryovers, and how that, and the ability to carry over time, and how that ties into what your policy says or what you think it says, because your policies don't always say what employers think they say. If a change is going to be made, well, before I get to that, the key issue to think about here is in many states, accrued PTO time, accrued vacation time, is considered to be the equivalent of wages. The view is that the employee has worked for it, they've earned it, it's something that is a wage to them. And so that's the perspective, excuse me, of most of the regulations, most of the laws, and most of the folks that enforce these things from a state and federal perspective look at. So what can you do to change these? Luckily, in most states, an employer is allowed to change PTO policies or vacation policies midstream in the middle of a year. What you have to do, though, in order to make that effective and valid, is to change it only on a prospective basis. You're not going to be able to go back and say, well, we're changing our policy on PTO time starting January 1, 2020. You can, however, if you were good about it and quick about it, say starting November 1, we will change our PTO policy from that point going forward. But in changing the policy, you cannot take away and should not be looking to take away anything that has already been accrued. So those are the basic ideas about PTO, and those basic ideas apply no matter where you are, no matter what state you're in. Look at your state, look at your own policy, and start from there. Next slide, please. There are some PTO considerations to take into account in looking at the Families First Coronavirus Response Act. As we know, there were two basic kinds of leaves there, and this act went into place back in March of this year. Given how much has changed since then, March seems like a time when dinosaurs were roaming the earth for all of us, because it seems to be ancient history. But this act will stay in place, at least until the end of this year. It is currently, as I think most of us know, set to expire at the end of the year. We all need to stay tuned because I'm sure nobody has missed the fact that there are some things going on in Washington right now. And whether and the extent to which this act and the leaves that are allowed under it is extended, renewed, or modified in any way is certainly going to be something that we all have to keep our eyes out for. But there are two basic kinds of leave here that were enacted and are now required. The first is the emergency paid sick leave, which would allow 80 hours, 2 weeks of time off with pay for employees. And the second is the emergency family leave, which would allow up to 12 weeks of time off. Now, how this ties to PTO has become a question that comes up quite a bit. When we're in that emergency paid sick leave mode, and we're looking at that 2-week period, as a general rule, under the Act, employees must be paid their regular rate of pay for that 2-week period, that 80-hour period. There is a cap of $511 a day, and 10 times that, $5,110 overall for the period of time that the employee is out. This leave, again, for those of you who don't know, and the pay for it is something that the federal government is providing, and it provides it to employers through an immediate tax credit that applies to your payroll, other payroll tax obligations. So in effect, you pay the employee, but you're given an immediate credit for it. Now, an employer cannot require the employee to use any of the employee's existing PTO time during that 80 hours when emergency paid sick leave is in effect. However, if the employee asks and the employer agrees, the employee could use PTO time to supplement the pay that they're otherwise receiving. Okay, so PTO time can be used by agreement to supplement and bring the employee up to their full rate of pay. I should also mention that if the emergency paid sick leave is being used for purposes other than the employee's own medical condition or quarantine, meaning if the employee is taking this time to take care of a child or to be with a child whose school is closed, in that case, the employee's pay is capped at $200 a day and a total of $2,000. So there are times when supplementing might be necessary, the employee might need it. If we're talking about the emergency family leave, after that first 2-week period, an employer can require the employee to use PTO time concurrently. So if you get into the emergency family leave, which really is the leave that applies when an employee is required for an extended period of time to remain home because a child's school or daycare is closed, you as the employer can require the employee to use their accrued PTO time. Pay, of course, if the employee is using PTO time, they're going to be paid at their full rate of pay by the employer. And as employer, you're not going to receive the tax credit for the period of time that the employee is using and being paid for their own PTO time. To the extent that the PTO time runs out and the employee remains on the emergency family leave, then you fall back to the 2/3 of pay up to the caps of $200 a day and $10,000 overall. Okay. Next slide, please. We've also seen, and many of you have seen, I know, a number of unemployment considerations here. They've related primarily to part-time work. Looking just at, excuse me, Massachusetts and New Hampshire, which is where most of you are located, the weekly maximum benefit for unemployment is $855, and in New Hampshire, it's $427. To the extent that an employer has been required to furlough or partially furlough or reduce an employee's hours and shift that employee from full-time to part-time work, there is still the opportunity for the employee to collect partial unemployment, but there are limits to that. In Massachusetts, once an employee earns greater than 1/3 of the weekly benefit that they qualify for, anything over that amount is going to reduce the employee's unemployment benefit dollar for dollar. New Hampshire has the same concept. It's just that once the employee goes over 30%, so a slightly different number, 30% of the weekly benefit, any earnings above that will reduce the employee's benefits dollar for dollar. And a few of us I know have been through those kind of complicated calculations to figure out where the break point is and where it makes sense to put employees on part-time work. Next slide, please. A general wage and hour update that has sort of been lost in all of this COVID talk is that as of January 1, the exempt salary level increased from $23,000, $23,600 a year, or $455 a week, to $35,568 per year and $648 per week. Substantial jump, but there had not been an increase in quite a long time. I mention this now for general purposes, but also for COVID purposes, because if you have an employee who is an exempt employee paid on a salary, remember that there is no prorated or partial consideration of this number, $35,568 a year. So that if you, for example, have an employee who's exempt, paid on a salary of, say, $50,000 a year, and you cut that employee back to part-time, exactly half-time, and you reduce the employee's pay by exactly half, so from $50,000 down to $25,000, that employee is no longer eligible to be considered exempt and must, from that point forward, be paid as a non-exempt employee. The hours must be tracked, and kept, and the employee must be paid as any other hourly rate employee is paid. The other thing to keep in mind here is that a number of states, significantly New York, California, and there are some others, and there are also some municipalities as well, especially municipalities out in California, that have a higher exempt salary requirement. So that you really need, from a wage and hour perspective, to keep track of all of this for purposes of understanding and making sure that your workforce, your exempt workforce, is fully in compliance. Next slide, please. The last thing I just want to talk about kind of quickly is the independent contractor issue. And I've got this slide up because the Department of Labor has noticed proposed rulemaking. The United States Department of Labor is following the formal rulemaking process under federal law, which requires any agency, federal agency, to put out notice of proposed rules, provide a comment period, and this is sort of I've got a picture of the window on the Department of Labor website here. If you wanted to submit a comment, you'd click on that green button that says submit a formal comment, and you could make a comment about the proposed independent contractor rule. Unfortunately, the comment period is 30 days, and that expired just 2 days ago, if my math is right. So you might not be able to submit a comment now, but that's what's going on. So the Department of Labor has issued proposed rulemaking about independent contractors. Important for all of us because, again, independent contractors and using independent contractors often creates a risk and has often been a source of significant litigation for employers. Realize, and I'm sure you do, that if you are classifying as an employer, classifying someone as an independent contractor, chances are you're not keeping track of the hours that person works. You're not really caring whether that person makes minimum wage. You're not keeping a record of hours, and thus you're not knowing about or thinking about whether that person has worked more or less than 40 hours in a week, and if they had been an employee of yours, might be entitled to overtime. The risk here is that if you get the classification question wrong, you would be, as the employer, responsible potentially for all of those things. And because you're not keeping records, you would be in a situation where the employee's word, the worker's word, is probably, not always, but probably going to be given more weight than yours as the employer. So it creates a real risk, and there are and certainly have been plenty of cases and plenty of class action cases brought springing from the misclassification of workers as independent contractors. One last slide on this issue. This is the substance of the Department of Labor's proposed independent contractor rule. And what they're really doing here is creating an economic reality test where they're trying to figure out if this person is someone who is in business for herself or himself, or is, on the other hand, really and truly economically dependent upon the putative employer. The rule is setting out two core factors. One is the nature and degree of control over the work. So the extent to which the employer is controlling the work that the employee, the supposed independent contractor, is doing. That's factor one. Factor two is looking at that worker's opportunity for profit or loss based upon their own initiative or investment in this enterprise. Corollary factors that will be looked at are the amount of skill that the worker needs to do the job. Is this a job that requires a very significant amount of skill and experience? Second, the degree of permanence of the working relationship between the worker and the employer. And third is whether this work is some integrated part, the extent to which is an integrated part of the employer's business. So think about it this way, because we've seen or read or heard about these cases where you have people who are supposedly independent contractors working alongside employees, working only for one employer, having worked for that same employer for 2-3 years exclusively, and where the employer is claiming, no, that worker's an independent contractor. That idea is not going to fly. It will never likely fly. And these factors are designed to look at those issues and to see whether that worker is someone who has their own business and is out there working for a number of employers. Regardless, actual practice is most employers will have a contract, and it's good to have, certainly, and you should, as an employer, have a contract if you have an independent contractor. But in examining these issues for purposes of an audit or litigation, what's going to be looked at is the actual practice rather than just what is said in the contract. The other thing to consider, and this will be my final word on the topic, is that there are many states, Massachusetts and New Hampshire included, that in addition to what is said by the Department of Labor, have their own laws dealing with independent contractors and what it will take to have an independent contractor. Those states' laws are on, like Massachusetts, like New Hampshire, are often a bit more strict than the federal standards. So you need to keep both in mind here in looking at independent contractors. And with that, I'm going to say thank you very much for your time and attention, and ask to advance the slide up to Karen's slide. Karen Whitley is now going to talk to us about disability accommodation and workers' compensation, which is a really difficult intersection in this era of COVID. Karen?
Good morning, everybody. So as Jim and Marcus said, I'm talking about reasonable accommodations, and I'm going to focus mostly under the Americans with Disabilities Act. Give some tips. Next slide, actually, Andrea. Give some tips about what to do if an employee asks for a reasonable accommodation during the COVID pandemic, and how COVID might change the reasonable accommodation landscape. And then I'm going to spend a few minutes talking about just a few changes that have been happening in the workers' compensation realm because of COVID. Next slide. So as many of you may know, one of the key aspects of the Americans with Disabilities Act is that it requires employers to give reasonable accommodations to applicants or employees who have a disability. However, the ADA does not require an employer to give a reasonable accommodation to an employee based on a disability of a family member. So if the employee is not disabled, that employee is not entitled to a reasonable accommodation. The EEOC has put out a guidance, which actually I'll share that when we post these slides later today. The EEOC has put out a guidance confirming that the employer is not required to give a reasonable accommodation based solely on a disability of a family member. So it has been very common for employees to ask for a leave or some other accommodation, telework or something else, because they don't want to bring home this virus to a high-risk spouse or a child with asthma, for example. And while this is a really sympathetic situation and it puts an employee in a tough spot and an employer in a tough spot, the ADA actually does not require that reasonable accommodation to be given. Another common request is for an employee to work from home, where there are less drastic changes to a job that can be done, an employer is permitted to choose among the various effective accommodations. And I'm just going to go this way. Kelly, tell me if this is better. Next slide, please.
Better, thank you.
All right, so what are some common reasonable accommodation scenarios that we have seen during the COVID crisis? So employers have been all along working with employees to develop reasonable accommodations, but we have seen that an uptick in that because of the situation that COVID has presented. So there may be high-risk employees or employees with pre-existing medical conditions who did not need an accommodation before and maybe now are coming forward and say that they do. There may be people who previously had accommodations in place, but for whatever reason, COVID has aggravated a disability or made it more difficult, more disruptive to an employee, and that employee now needs some sort of expanded or different accommodation. One thing we've seen a very significant increase is the number of employees who are coming forward with mental health issues, where they maybe previously were able to manage anxiety or some other mental health condition. And now, just because of the situations they're faced with, fear of getting sick, fear of bringing issues home, that is a feeling that many people have. But for people with a mental health disability, that has gotten to the point where it is interfering with their ability to perform their essential functions, and they may be coming forward and asking for an accommodation of some sort. And then finally, we are seeing people who unfortunately have become very sick with COVID and have developed some sort of temporary disability. They just can't shake that fever, that ache, that cough, and it is preventing them from coming back to work. So that may rise in certain circumstances to the definition of a disability and may need to be accommodated in some way. One thing that we've also seen a lot of is this difference between the treatment of essential workers and non-essential workers. Not something a lot of us had spent maybe a lot of time thinking about before, but it now is very much discussed, And employers may feel like if they have an essential workforce, that those people have been decreed that they're important and they need to be there. But it is important to understand that even essential workers may be entitled to reasonable accommodations, and it's going to be a matter of what is reasonable in that circumstance, and whether the accommodation can be granted without an undue hardship. Next slide. So 10 months ago, the phrase social distancing didn't mean anything to most of us. But now that is the foundation of many of the reasonable accommodation requests that we're seeing. The need to stay away from other people. And this can be as simple as moving someone from a cubicle to an office, but it may also be more complicated, such as temporarily restructuring a job to take away some of the marginal job duties that might cause more exposure with coworkers or with the public. Maybe temporary transfers to a different position, or even modifying work schedules. Maybe some people come in really early and get to leave earlier, so there's less opportunity for overlap. As I mentioned, there may be opportunities to expand prior accommodations that were in place. But I would say the two primary requests for accommodations that potentially cause the most disruption to employer operations are the last two on this slide, the telework and the leaves of absence. Next slide. So I'm going to spend a minute talking about leaves of absence. We've been talking about the Americans with Disabilities Act, but there are at least two other laws that employers should look to first or think of first when talking about a leave of absence. The first is standard FMLA. It's been in place since 1993 and allows employees to take up to 12 weeks of leave in most situations for a serious health condition or to care for somebody with a serious health condition. So there may be opportunities to take care of somebody who is sick at home due to COVID under the FMLA, or for the individual employee if their COVID exposure rises to the level of a serious health condition, as that is defined under the FMLA and its regulations. There may be opportunities for people to take leave under that law. And as Mark talked about, and Jim, the FFCRA has allowed two different types of leave. So the paid sick leave, which would be most applicable here if somebody develops COVID or COVID symptoms or is taking care of somebody who has. So that from a disability perspective would be those 2 weeks, those 80 hours of paid sick leave, when they're advised by a healthcare provider to quarantine or if they're actually sick or experiencing symptoms. So those two laws are where employers probably should look first to see if those apply. Because the ADA has been interpreted to allow unpaid leave as an accommodation, but it doesn't allow indefinite leave as an accommodation. And I would, the other point here is that pre-COVID, employees who were able to show, I have a disability, I either have exhausted my FMLA rights or I am not eligible for FMLA because I haven't been working long enough or haven't worked enough hours for this employer, employees could take this ADA leave and that it was unpaid, typically, unless the employer had some sort of policy to substitute paid leave. Or they could, employees might be eligible to take short-term disability leave through an employer program. But it was typically unpaid. During COVID, in most states, many states, and certainly in New Hampshire under the emergency order number 5, employees were able to collect unemployment for COVID-related leave. So we received a lot of questions about, normally I would give this person a leave of absence and it would be unpaid, but they're telling me they're going to go collect unemployment instead. So it did turn that whole system a little bit on its head. I think as there was talk earlier about the incentive that the CARES Act gave to have people collect unemployment because of that additional $600. maybe that is dwindling at this point. Next slide. And I will just say, from a leave of absence perspective, for those of you who are in Massachusetts, January 1st, 2021, we will be seeing the implementation of several parts of the Massachusetts Paid Family Medical Leave Act, which will allow leave for an individual's own medical condition. So that could further complicate things. So in this era, employers have wanted to be generous, have wanted to do the right thing, haven't wanted to step into any disability discrimination issues by asking too much, but there is potential for abuse, for employees who say, I have the sniffles, that's a COVID symptom, I need to take leave. The questions become, for an employer, how much can we ask? How much can we press back? What is fair for us to do? What is legal for us to do? So I've set out here a couple of the questions that the EEOC has over time said that an employer can ask about whether an employee has a disability that requires a reasonable accommodation under the ADA. And one of the first questions is, does the employee have a condition that rises to the level of a disability? And if so, what are the limitations on that disabled employee's ability to do the essential functions of their job? So, very easy question to ask. What are the limitations? The answers aren't always easy to interpret or to put into place, but those are questions that employers can ask. And they also can ask, if you're asking for an accommodation, how would we be able to provide you that accommodation to allow you to do the essential functions of your job? Are there alternative accommodations? And you can do all of this in a communication to a healthcare provider that asks for medical documentation. If you're providing the reasonable accommodation also, you may want to set an end date on the accommodation. In this case, we may want you to be saying, when the state of emergency is over or at a certain period of time, we're going to revisit this. Next slide. So the other problem here, or the other consideration here, is that employers do not need to provide a reasonable accommodation if it will cause an undue hardship. Remember that that is always something the employer can consider. But pre-COVID, it was a lot harder for an employer to deny an accommodation based solely on the cost or expense of the accommodation that the employee was asking for. The EEOC guidance that they issued this fall confirms that the circumstances of this pandemic could lead to an undue hardship for an employer to offer an accommodation if the accommodation that is being asked for is logistically or financially more difficult. And if, in fact, the employer decides that it would be an undue hardship for them to grant whatever that accommodation request is, employers and employees should try to find an alternative accommodation. Next slide. So where does that leave us in terms of the future? I think we've already seen, and there will continue to be an impact on the reasonable accommodation process. But more broadly, employers are now becoming more aware of employee health conditions and employee families' health conditions. The employer has more knowledge now because people are coming forward to ask for medical, I'm high risk, I have this particular diagnosis, it was never an issue before, but now I'm high risk and I'm concerned. Or I can't perform my job, or I can't be here, or I have a mental health consideration. So watch for retaliation. Make sure that you are not making judgments in the future now knowing this additional medical information about people. And finally, on the remote work as an accommodation issue, many employers were unwilling to offer that as an accommodation or to grant that as an accommodation, saying that presence in the workplace was an essential function of the job. The need to be able to have those hallway conversations and to have sort of collaborative teamwork in the workplace were considered to be essential. This will possibly change that landscape. Zoom and other platforms have helped people collaborate across the distance. So employees may have a little bit more solid footing to say, no, it's not a reasonable accommodation. It is not a, it is a reasonable accommodation. It is not going to diminish my ability to participate in the workplace. But the EEOC has said that granting telework during this time does not require an employer to always grant it in the future. It will be a case-by-case question, but employers should take into consideration what they've learned during this trial period. Next slide. So just to speak briefly, I know there's a lot of questions that we want to get to, so I'm just going to speak very briefly about the changes under workers' comp during this period of time. Go ahead. Next. So the situation that some of you may have seen or be concerned that you will see is that an employee who contracts COVID might seek benefits due to and claim that they got COVID at work, that it was a workplace injury or an occupational disease. So generally under workers' comp, in order to be eligible to recover benefits, somebody has to be able to show that they have an injury or illness that arose out of and in the course of their employment, and that it was due to causes characteristic of that work environment. So essentially the question is going to become, was the employee exposed to harm, in this case coronavirus, while involved in an activity for the employer's benefit? Next. But because of the nature of COVID and the highly contagious nature of it, the incubation period, the fact that that people may spread the virus while asymptomatic, many states have enacted laws or guidelines, guidances to make it easier for certain employees like the frontline healthcare workers, first responders, and other essential workers to receive workers' compensation benefits if they test positive or are impacted by COVID. Next. So what have some states been doing? This is what I'm currently aware of, but this list is continually changing. Several states have adopted laws, changing their workers' compensation laws. And if you have employees or workers in any of those states, you'll want to be aware of what the presumptions are, what the changes are. Some states have done it by executive or emergency order, or just by an advisory. You know, the workers' comp, the agency that manages workers' comp may have issued a policy statement. This is how we're going to interpret this term in light of COVID. So you'll want to be aware when you have workers in any of those states of what the source of the change is and what the content is and how does it affect the workers in your state. But again, keep an eye out for changes in particular. Next. So in New Hampshire, in particular, there have been an emergency order that was amended by a later one that does change presumptions or add presumptions for first responders or emergency response public safety personnel. And when those individuals test positive for COVID-19 and it's reported to the state, there's a prima facie presumption that the exposure and the infection were occupationally related so that the employee would presumptively be entitled to benefits. Massachusetts has legislation and has for a while legislation pending to protect EMTs and other essential workers. So if you're in that space, it may be something you've already dealt with, but wanted to bring that to your attention. Next. So just speaking very generally, in states where there is a rebuttable presumption that a worker contracted COVID at work and that that incident would be compensable under workers' comp, the question is, is there any opportunity for an employer to challenge that? And some of the states have set out the types of things that employers would have to do. For example, showing that the workplace precautions taken by an employer and their compliance with CDC guidance and other COVID guidance was really strongly enforced, and that it is unlikely that the employee actually caught COVID at work. And also, on the other hand, showing that the employee's own conduct outside of work may have contributed to their becoming infected. So their risks outside of work, their lack of compliance with safety measures, et cetera. So, it is an evolving area. Next slide. But to wrap up, I thought I would just provide some predictions about how certain categories of workers might be able to claim workers' comp. The first being healthcare workers and first responders. In the states that we've talked about, there are actually presumptions in favor of those workers. It's likely yes, because of the nature of their work and the fact that they're out transporting people to hospitals who are COVID positive, for example. Those people likely would be able to recover. Other essential employees, maybe, depending on state law and the burden of proof in the state law in that particular state about whether exposure in the workplace within a certain period of time prior to them becoming sick would allow them to recover. Other workers, it's unlikely that there would be a presumption in their favor, but certainly if they can show a documented exposure in the workplace and that they got sick within that expected incubation period, might be able to. And then that brings us to remote workers. It is hard to see how remote workers could claim workers' compensation that they, based on the fact that they contracted COVID, when they have actually been removed from the workplace as a safety measure to prevent them from getting COVID. But we will wait for a test case to see whether that happens. And for the moment, it's a big question mark. So with that, I will pass it back to Jim and Mark and Kelly for questions. And thank you for joining us this morning.
Karen, thank you very much. Mark, Jim, Karen, could you please address some of the questions now?
Sure. Good morning. And this is, as Karen said, an evolving area of the law, and we send out daily notices, and you folks have read them on the DOL website through the FAQs and so on. It's going to continue to be an evolving area of the law, and the fact that you, as HR professionals, remain updated and nimble in your approach and also applying common sense is critical. So a couple of questions that came up. I'll start that off and we'll turn it back over to Mark and to Karen, and no real formality to that, is will the FFCRA be extended beyond December 31st? I'd love to have a poll question on that because the answer is, who knows? I think it's entirely possible that it could be, but right now plan to have it expire on 12/31. I keep your policies in place, but I think it's entirely possible. I think we would all agree that if you're looking at a second and third wave, if this takes us through the winter and into next spring, there's no question, because there has to be some way to protect employees' employment, to keep people working to the extent possible, and so on. So that comes up. One question that came up was, well, we have our employees already used the emergency sick leave this spring. The 10 days available, the 80 hours, 80 hours rather. But I mean, I think that understood that's happened across the board. But and then what happens when it's exhausted? Use the PTO or it's unpaid leave. Another question came up with, and we've seen several questions of this. Can we require quarantine when there's personal travel? Well, that's what OSHA and the CDC say, and that's what the local Department of Labor Department of Health, Public Health in New Hampshire has said that except for essential medical travel and business travel, if someone travels outside of New England to a hotspot, regardless of the mode of transportation and regardless of what they did, if they're outside of New England, they have to quarantine for 14 days. Now, that to me is a bit awkward because the question is, what are they doing and whether they're exposed? But that is the guidance, and therefore, if you're FFCRA covered, the employer can use that benefit to the extent possible. But what if the employee's exhausted it? If they've exhausted it, then it's PTO. That's why you have to have a conversation with the employee. Now, is that the law? Again, in New Hampshire, it says we ask. But the other part to the ask is in the guidance, it says that the Department of Public Health has enforcement authority. So, and we've actually seen that in 2 instances already. The part that doesn't make any sense, though, was what about someone who travels for business? And They're traveling all over the country. Why is it they don't have to quarantine the same way? And I guess it goes back to the screening questions. You're going to continue to ask the screening questions. Do you have any symptoms? Have you been exposed to? Are you under a doctor's order? And so on. So I think that is, and finally on that point, someone said, what do you do with the screening logs? So you've got those daily screening logs. Or there's another question that comes up that's related that says that I've got the postings, we've got the policy, but we're not taking temperatures. I think early on, if you wanted to buy stock in addition to Home Depot and Amazon, if you bought stock in the companies that did the thermal scanner for temperatures, you'd be wealthy today. But that has sort of fallen by the wayside, and it was individual attestation. Yes, I'm coming into work, I don't have a fever. The question was, is the policy sufficient in that regard, or do you need to have individual attestations? On the temperature, the CDC says that's no longer really determinative as when the person is sick. They could actually be asymptomatic at that point and coming into work. So really the questions are, do you have any other symptoms, or have you been exposed to someone who is known or suspected to be COVID positive? But what do you do with the records? Keep the records like any other confidential medical record. And I would say, because we're dealing with a couple of OSHA audits at this point, you want to be able to produce records to say we've been diligent in following the screening guidelines. With that, I'm going to turn it back to Mark and Karen to talk about some of the other questions come up. We've got at least 30, 35 questions here.
So thanks, Jim. I'll take a couple right now. Question being asked about the wage and hour issue that I raised concerning exempt employees who are partially furloughed on a temporary basis. And the question is whether, if someone is an exempt employee and they're partially furloughed on a temporary basis, to the extent that their salary is reduced below the amount that would qualify for exempt status, do you need to change that person to an hourly position? And the answer is yes. For the period of time that an employee is not making the minimum required salary to be exempt, they do need to be paid on an hourly basis, even if the furlough is only temporary. So the answer to that question is yes. Another question is about the proposed independent contractor regulations and the likelihood of them becoming final. And I would say this, in part, it's going to depend upon the results next Tuesday. If the administration doesn't change, they will become final, I'm sure. If there is a changing of the guard, then the question, I think, is going to become whether those regulations can be made final before there is a changing of the guard. But I think it's pretty likely that they will become final. Karen, do you have any questions you want to address right now?
Sure, there's a couple, I think actually three. So somebody had asked for a link to the FSCRA for more information, and I basically Google FSCRA FAQs, and that has, I don't know, something like 130 or something like that, frequently asked questions that are broken down by topic. So that's a great place to learn a little bit more about the FSCRA. Two other questions that I saw, or one was a question, one was a comment that I thought was good. The first is, if an employee is out due to COVID concerns or is high risk and hasn't responded to calls to check in or confirm that they need more time out of work, do we have any suggestions on how to handle that? And from a reasonable accommodation perspective, it's important to keep in mind that the reasonable accommodation process is an interactive dialogue. It's a two-way street. So if an employee asks for, or it's obvious that they need a reasonable accommodation, and the employer is entitled to ask for the information that I talked about during my presentation. But if the employee doesn't return, a questionnaire or medical documentation, and the employer emphasizes that that's really needed in order for the employer to decide whether the accommodation is reasonable, then the employee is failing to participate in that interactive dialogue. And there is case law that if the employee fails to participate, the employer is not required to give that accommodation. So where somebody is not responding to calls, if they don't provide the information that's requested, or they're not providing, not answering the phone, you can't get in touch with them in any of the normal methods that you would use, you should send them some written letter saying, we're waiting to hear from you after such and such date. Your absence will no longer be excused. You've used up all your PTO, and after that point, we will have to take next steps with regard to your employment. So that is, it is possible to stop the interactive dialogue if somebody is not participating in that. And the other comment was someone noting that employers are being much more forgiving of work from home currently because of the pandemic, but that doesn't mean that employees are truly working successfully or meeting the standard. And I think that that's what the EEOC has recognized, that there is some flexibility, but that employers are giving right now, but that does not mean you are permanently changing the essential functions of the job. And you do have the right to bring those people back along, following the safe guidelines that Jim talked about, by continuing to say that those, presence is an essential function.
Jim, let me jump in and answer one more question. It's, as I'm scrolling through here, it's sometimes difficult for all of you out there to follow all these questions, but there is one that I think is important and is probably being asked by a number of employers. And the question is, for non-exempt employees, are they on the clock if they are going out for a COVID test at the company's direction and request? And the answer to that is yes, they are. If an employee is doing something that is at the request or a requirement of the employer, then yes, that is on the clock and compensable time. So you should all take that into account when tracking time for hourly employees who are being asked to have a COVID test. Thank you. I'm all set with questions here. I know we can't get to them all, but if there are others, Jim or Karen, feel free.
I just want to, as we wrap up today, thanks, Mark. Two quick questions. One that came up that's an FFCRA question is that we are a manufacturing facility, and as a result, we have limited opportunities for people to work remotely from home. So, of course, that would be, if you're fewer than 500 employees, that would be a typical FFCRA situation, at least through the end of December, where the person may be able to take advantage of if they, under the guidelines, are quarantined and the like, or have symptoms, or if their kids are, their school is closed and so on. But if not, you've got furlough, potential layoff, and unemployment issues that could come up for purposes of the employee. Because if the employee can work remotely, then FFCRA doesn't apply. But if they cannot work remotely, then it may apply. Otherwise, you've got, like I said, unemployment, furlough, and unemployment, and so on. The last is that I want to get to, and I just kind of snicker at this, but it's a serious question. So we've got someone working remotely, or they're supposed to be quarantining and they can't work remotely. Can we keep an eye on them through social media? Can we, through Facebook or otherwise, or if whether we're their friend or a coworker is their friend, can we keep an eye on them? What are the legal issues associated with that? Of course, we know in New Hampshire, you cannot ask for someone's username, password, or ask them to like your site, because if they do that, that's a portal for you to get in and look at their social media. But otherwise, if the person has a public profile, not a private profile, can you keep an eye on them? This comes up in workers' comp all the time, or it comes up with misconduct issues. Can you? Yeah, you can. You're better off basically avoiding situations like that, because if you go into that portal, you might see things you cannot unsee. And that, whether it's someone's association with a certain group or political stand or medical issues or other things that may come up, and that gets a bit tricky. So best to, if at all possible, just having the strict guidelines with the, as Karen mentioned, under the FAQs from the Department of Labor, whether or not someone qualifies for the emergency paid leave or otherwise. But be careful with the social media monitoring. It's legal, but it's tricky. So that's it for today as we wrap up. I want to thank Karen and Mark, a terrific panel today. I think we try to stay within our timelines. We can follow up with other questions offline, but remember, as Kelly will tell you, the second part of this is coming up later in November. But in the meantime, thank you so much for taking time on your Thursday morning to be with us. Kelly?
Thank you. Thank you, Jim, Mark, and Karen. The materials will be circulated later today, as well as posted on LinkedIn. So please check that out. And lastly, if you are interested in further information in the continuance of this program, you will need to register for the November 19th program on our website. Thank you and have a great day, everyone.